Hi guys, my name is Marc Victor and I'm a criminal defense lawyer with the Attorneys for Freedom law firm in Chandler, Arizona. I've been practicing criminal law for over 25 years now. Most of what I do is major felony cases. I've had everything from first-degree murder with the death penalty alleged, which I've tried on several occasions, all the way down to crazy little misdemeanors. I also have been practicing in the federal courts throughout Arizona and also throughout the country for the last 25 years. And we do appeals at our law firm as well. I've been to the Ninth Circuit several times. I've argued there. We've won on several occasions. So I've been around the criminal justice system. And today I want to talk to you a little bit about self-defense, deadly physical force, the kinds of things you need to know if you're going to carry or even possess a firearm. We're going to talk about not just your rights to keep and bear arms, which are very important. That's a subject maybe for a different day. Today, I want to talk about your responsibilities. You got responsibilities if you're going to be an owner of a firearm. They're legal responsibilities. They're things that you are held to know and certain conduct that you are required to sort of conform to the law, or you can get yourself in a lot of trouble. So I want to start right out talking about self-defense and deadly physical force. Look, this is important stuff, right? People don't get this. And I find a lot of clients come into my office because they've made very important, very serious mistakes in judgment by pulling out their firearm. So let me start by saying just sort of the 30,000-foot overview. Whatever you do with your firearm or your fists or a knife or any other instrument, even something like this pen right here could be used in self-defense. Whatever you do, any physical force that you use against another person is going to be judged by one very important word: reasonableness. That's really the question. At 30,000 feet, that's the question that we are asking a jury to decide. If you go to a jury trial, that's in essence what we're asking the jury to tell us back. We're saying, look, now that you've heard the witnesses and you've seen the physical evidence and maybe you've heard the defendant testify or not, but you've heard everything about this case, ladies and gentlemen of the jury, we need you to tell us something. What do we need you to tell us? Considering everything, is what the defendant did, is that reasonable? That's really the question. Is it reasonable? Because if it's not reasonable, that in essence means you broke the law. And if you broke the law using a firearm, you're going to be in very likely for a long prison term. So there is some guidance in terms of what's reasonable. We don't leave you just with the general idea that you got to act reasonable, right? Because people have different ideas of what's reasonable. So the legislature of every state has given you some guidance. They're called statutes, and they give you some general ideas on what that state considers to be reasonable. Now, I practice in Arizona, okay? That's where I'm licensed to practice. And so I'm going to speak specifically about Arizona law. If you're outside of Arizona, most of this stuff is still going to apply to you, but you really should consult an attorney who's licensed in your state, because there are some differences among what's considered reasonable state to state. But I can tell you this, generally speaking, if you're using physical force against another person, you better have something more than that other person was sort of yelling at you or using mere words, as we like to say. Because as a general rule, verbal provocation alone isn't going to be enough for you to invoke self-defense. And I don't care what they were saying. If they were saying something hugely offensive to you, they were insulting your significant other or your favorite sports team or your religion or something that you hold very near and dear to your heart, it still doesn't matter. You don't get to punch them in the face because they offended you. This is the United States of America, and we have free speech here, and people are allowed to say things even if they're offensive things. But let me drop a little footnote in there. Words alone, absolutely. You can't use force and claim self-defense. But words coupled with some kind of action, even however slight. Imagine somebody now is saying something horrendously offensive to you, and as they're saying it, they've got their fists clenched like this, and they're approaching you, and they're going like this, and it looks like they're about ready to hit you in the face. If the threat is imminent, you're in business. That's another one of those things that the legislature is going to give you a hint on about what's reasonable. If you're going to use self-defense, the threat against which you are reacting to, it's got to be imminent, right? So even if somebody says, I'm going to punch you in the face tomorrow, that's not going to be good enough. You're going to have to wait until tomorrow. If you punch him in the face right now, then you are acting unreasonably, and you're going to be convicted of an assault. I'm going to talk about an assault in a little bit here, but the key thing I want you to understand now is if you're claiming self-defense, you better be saying the risk of harm to you or another person was imminent, which means it was going to happen right now. Not 5 minutes from now, not even 1 minute from now. Right now. It has to be happening right now. And if it's not right now, then you're acting unreasonably. You got to keep that in mind. You don't get to have sort of a preemptive strike unless it's right now. You don't have to wait till somebody hits you in the face, but they got to be pretty close to making that happen. Okay? So verbal provocation alone, not enough for self-defense. If the threat's not imminent, not enough for self-defense. Let's talk about property. If somebody is stealing your property, yeah, you can use ordinary physical force to stop that from happening. No problem there. But you can't use deadly physical force. The response to the threat needs to be proportionate, right? If somebody is sort of threatening to slap you in the face and you pull out your gun and shoot them, you could have acted in self-defense, no doubt, assuming that the other person is the aggressor. You have every right to defend yourself. But you don't have a right to use excessive force. You didn't need to shoot and kill the person. You could have just pushed him away from you, and that probably would have been enough. So if you use more force than is reasonably necessary, then you are acting unreasonably. So just because somebody is an aggressor, and just because you get to use force to defend yourself, you are justified in defending yourself, you still got to make sure you're not using more force than is reasonably necessary to repel that attack. It's not carte blanche to do whatever you want, to sort of beat the person or pull out a firearm if you're only talking about property. So I can tell you, in most of the states in this country, certainly in Arizona and in the federal system, you're not going to get to use deadly physical force if somebody is simply stealing your property, right? You're going to be held to be acting unreasonably. And once you're in the unreasonable box, think of that as getting convicted in a criminal case. You have to act reasonably. Now look, different circumstances are infinite. Right? So we can't give you sort of a default rule for every circumstance. This is why we need juries. And also, it's a good reason why I think you ought to be very conservative. So maybe this is a good time to talk about things that lots of gun guys like to talk about, like the castle doctrine. So let's talk about that for a moment. In most states, even the majority of states in the United States, you do not have a legal duty to retreat. Certainly that's the case here in Arizona. In some states, a minority of states, some of them back where I'm from, like in Massachusetts, states in the East Coast, you have a legal duty to retreat if you can safely retreat. However, even in those states, there's an exception. The exception we call the castle doctrine, right? Your home is your castle. And so if you're in your home, you don't have to retreat. The idea there is that there is nowhere to retreat to. I mean, it's your home. You are the sort of king of or queen of your castle. And so in those states where you have a legal duty to retreat, the castle doctrine generally applies, and you don't have to retreat if you're in your home. There's no need to talk about the castle doctrine in a majority of states, like Arizona, because there's no legal duty to retreat. But now that I've got that out of the way, if you can safely retreat, this is my personal opinion, you'd be really foolish not to retreat. Why? Because sometimes the bad guys win, right? Bad things can happen. You may make a judgment that puts you into the unreasonable box as well. So what I'm saying to you as a criminal defense lawyer, as a fellow pro-gun guy, pro-civil liberties person, you should retreat if you can, just to be safe. Check your ego at the door and get out of there. Avoid the problem. Use your brain to avoid the situation. Because although I think we got a pretty good justice system in the United States, yes, there are problems. Yes, there are things I would change. And many of the laws are wrong, right? We should do away with victimless crimes. That seems a no-brainer to me. But our procedure, in terms of how we process cases through the system, our evidence rules, our procedure rules, pretty good. You're going to get a fair trial in most places in the United States. But even there, people who are actually innocent do get convicted. Some of them, even with all of the protections in our justice system, get sentenced to death. We've had innocent people sentenced to death in the United States. We've had them in Arizona. So be careful about that. Don't ride just on, hey, I'm really innocent, therefore I'm not worried about going to trial. Even if you do win, it's expensive and it's stressful and it goes on for a long time. You do not want to be prosecuted. If you can avoid that, the smart thing to do is avoid that. And that's why my advice is generally very, very conservative. So let's talk about assault for a minute, because this is, in my opinion, the most common crime that people, either with a firearm or even without a firearm, people who try to use self-defense, this is what you're most likely to be charged with if you make a mistake. And I think this is the case because people don't really understand the nature of an assault. I have people who come into my office on a fairly regular basis who are charged with either assault or aggravated assault, and they sit down with a big smile on their face right here in this office, and they say, "Hey Mark, this is going to be an easy one." And I say, "Oh, why is that?" And they say, "Because I never touched the person, and I'm charged with assault." Well, imagine how they must feel when I tell them that touching a person isn't required in most places for an assault. Yeah, there are different ways that you can commit an assault. Some states we call some of these ways a battery. At common law, much of this was called battery. But here in Arizona and a lot of other states, the crime of battery and the crime of assault have been put together, and there are just different versions or different varieties of an assault. One of them is the most common, the type that most people understand when they're charged with an assault. It's intentionally or recklessly causing a physical injury to another person. If you did that, you were not acting in self-defense, you were not justified, you were the aggressor, and you intentionally or recklessly, which, let me pause on that for a moment. You weren't intending to cause a physical injury to somebody, but you were doing something, and you knew you were doing it and it was risky, and you knew about the risk, but you disregarded that risk. You did it anyways, and that caused a physical injury to another person. That's an assault. Fine. There's another way to commit an assault. You don't have to cause a physical injury to another person. All you got to do is touch them. Any touching, even flipping off somebody's ball cap, somebody who's wearing a ball cap, just flipping off their cap, that's enough for a touching, right? You could potentially even spit on somebody's windshield as they're driving their car down the road, and that could be considered a touching. But if you touch somebody with a certain intent, what we criminal defense lawyers call mens rea, that's the Latin term. It's kind of what's going on in between the ears. If what's going on between the ears is you are intending to either injure or insult or provoke another person, so think of all of the occasions where, people might poke someone in the chest and say, "Come on, man, punch me, just punch me. Come on. They're already committing an assault. That person is the aggressor, right? Because they're touching with the intent to provoke, or touching with the intent to insult or injure. So any of those, that's also an assault. And then the last variety, the one I sort of opened with, the one that doesn't even require a touching. Think of this assault as actually occurring in the mind of the victim, right? What you're doing here is you are intending to cause somebody to be scared, or in apprehension, as we say in the law, of an imminent physical injury. So think about, picking up a rock maybe and pretending like you're going to throw it at the person, and you go like this, and you don't throw the rock, you hold on to it, and the person goes like this, and they're scared about being hit with the rock. That's an assault. Even though you didn't touch, even though you didn't injure, that's still an assault, because you caused somebody in their mind to be imminently scared of an immediate touching, an immediate injury, I should say. So that's an assault. So you can imagine now taking the assaults I just described, which are generally misdemeanor crimes, right? Crimes are divided up into felonies and misdemeanors, and sort of the dividing line across the nation is the answer to the question, how much time could you potentially do in a prison cell? Well, if it's 1 year or more, you're talking a felony. If it's less than 1 year, you're talking about a misdemeanor. And in Arizona, 6 months is the most time you can serve on the most serious of our misdemeanors. So there's a difference between felonies and misdemeanors. Taking that assault I just described, all three versions of those are misdemeanors here in Arizona. If you want to elevate that to a felony, that's pretty easy to do. There are many different ways to elevate it to a felony. One way is using a firearm. If you scare somebody, you pulled out your firearm, and you scare somebody, causing them to think that they're about to suffer an imminent physical injury, that's an aggravated assault with a firearm. Just because you pulled out your firearm when you were not authorized to do so, when it was unreasonable. And what's unreasonable? Well, when you pulled it out when somebody else was not presenting an imminent threat of death or serious physical injury. That's when you get to use deadly physical force. If there's an imminent threat of death or serious physical injury. Now, different states are going to define that differently, but you can imagine a serious physical injury is more than sort of redness on your face, maybe more than even a black and blue eye. You're talking broken bones. You're talking an injury that may alter the course of your life going forward, even temporarily. You should know the trend in considering a serious physical injury is sort of less serious and less serious all the time. How do you avoid this? Keep your hands off of other people. Be very conservative in terms of using force. But as a general rule, if you want to use or threaten to use, like pulling out a firearm, threaten to use deadly physical force, you better be reacting to an imminent threat of death or serious physical injury. Otherwise, you're acting unreasonably. How else can you get that misdemeanor assault up to a felony assault? There's lots of different ways. If you change that physical injury into a serious physical injury, now you intentionally or recklessly cause not just an ordinary physical injury, but a serious physical injury. That's an automatic ticket to the felony world. Okay? There are lots of other ways. If you commit a felony after entering somebody's home, enter someone's home with the intent to commit an assault, you're generally looking at a felony. If you're an adult and you beat up a kid, you're looking at a felony. If you injure somebody who is substantially incapable of resisting, right? Imagine a sort of a barroom situation and your buddy gets into a fight and he beats up someone else and now they're on the floor sort of recovering, and on the way out the door you kick them. Where that might have been an ordinary misdemeanor assault because they were substantially incapable of resisting or incapacitated in some way, Lots of states will hold that as a felony aggravated assault. So those are some of the ways that you get up to the aggravated assault world. Also, some of you guys will be familiar with orders of protections, or sometimes called injunctions against harassment. Slightly different situation here in Arizona, but you're talking about a restraining order that says don't contact, don't touch, don't come near, whatever. If you commit an assault in violation of one of those, you're generally looking at a felony as well. So you got to be very careful and act reasonably. A couple other things I wanted to talk about. The burden of proof. You might want to keep your eye on the burden of proof for self-defense in your state. When I started practicing about 25 years ago, the rule on this in Arizona was slightly different. Self-defense was in Arizona at that time considered what we call an affirmative defense, and it still is in many states. What that means is, if you get charged with a crime and you want to assert, hey, my defense to this crime is self-defense, you got to prove that up. You got the burden of proof. And in most places, it's by preponderance, which means more than 50%. So you've got the burden as the defendant in a criminal case, if you're going to allege self-defense, to prove it up. Now, that is not the rule in Arizona any longer. Arizona has changed the burden of proof, and now the way it works is if you assert self-defense, you put some evidence forward of, hey, I acted in self-defense. The burden now is on the government to prove beyond a reasonable doubt that you did not act in self-defense. So much more sort of defendant-friendly in Arizona if you allege self-defense. You may want to check your state and get some idea of what the burden of proof is. Who has the burden of proof? What is the burden of proof? Is it preponderance? Is it something higher than that, like maybe clear and convincing evidence? Check what your state is so you'll have an idea of what you would have to sort of show if you asserted self-defense as a defense. Also, we've got a statute in Arizona called 13411. Title 13, Section 411. It's our crime prevention statute. Some other states have this statute. It's sort of a strange statute because in essence what it says is you can use deadly physical force if it's immediately necessary to stop another person from committing certain felony crimes that are listed. They're enumerated in the statute. I'm not going to go through all of them because I want to keep the length of this video reasonable. But in Arizona, there is a defense that you can shoot and kill another person if one of those, if it's immediately necessary, and that's kind of the key, right? It has to be immediately necessary to stop that person from committing that felony offense. There's also some burdens of proof in there. If you assert 13411, then you're presumed to be acting reasonably. And as we started out with, the word reasonable is really important to the analysis in self-defense. It's rebuttable. So what that means is the government can come in and say, yes, even though there's this presumption, here's the evidence to suggest that the person actually acted unreasonably. I don't love this section because I think it can be difficult to show that it was immediately necessary to shoot and kill a person to stop them from committing a particular crime, right? There are many other options available. You could call 911, you could maybe use ordinary physical force. There are things that you can do. So I don't suggest that people sort of rely on that statute, but you may want to know whether there is such a statute in your state, because this goes to another very important rule. It's the sort of just shut up rule. If you do find yourself in a shooting, there can be many different justifications for the shooting, right? Maybe you shot somebody because you were in fear for your life. That could be a perfectly legitimate reason, so long as you were reasonably in fear for your life and it was an imminent threat to your life. That could be a perfectly good defense. But there are other defenses that can be brought to bear and can be successful in these types of cases, like I shot because I was defending a third person. Yes, you can generally stand in the shoes of a third party and assert their self-defense rights as if you were asserting your own. If they've got a right to defend themselves, you can stand in their shoes and defend them. That's another reason, completely separate from the I was in fear for my life. This is, in essence, I was in fear for another person's life, which was imminently about to be taken, or they were about to suffer a serious physical injury, completely different reason, completely different justification, just like 13-411 that I just discussed. That might be the reason you shot and killed another person. I was trying to stop them from committing a murder, an arson, a rape, one of the crimes listed on that list. If you opened your big mouth and said, here's the reason, well, you're stuck with that reason. I think it might be more prudent. In fact, I'm pretty sure it's more prudent for you to just keep your big mouth shut after a shooting and don't follow the, I think, too general advice that some other people give to just say, hey, I was in fear for my life. Don't do that. Just keep your big mouth shut. You might say, hey, I want to talk to an attorney. I want my attorney present. You should be very certain about that. Don't sort of be wishy-washy. Don't equivocate here and say, well, I don't know, do I need an attorney? I think I might need an attorney. None of that stuff is going to be effective. I want my attorney present before I answer any questions. That's what I want you to say. Don't worry. It's not going to be used against you. It's not coming up at your trial. A jury's not even going to hear that you insisted that your lawyer be present before you answer any questions. You got a Fifth Amendment and Sixth Amendment rights that come to bear that you can assert, and a jury is not permitted to make any negative inferences about this. So as a result, juries don't even get to hear about this. So don't worry about that. Keep your big mouth shut. I also want to talk about a little bit about mistake of fact, because you may have shot somebody or used self-defense and then after that realized, oops, I made a mistake. I was mistaken about some fact, right? This person seemed like they were presenting an imminent threat of physical injury or serious injury or death, whatever, but as it turned out, I was mistaken about that. Well, if that mistake is a reasonable mistake, that may help you escape criminal liability for the act. So again, keep your mouth shut. Even if you made a mistake, don't open your big mouth and say something about that, because it may be permitted by law to get you out of a criminal prosecution. You may still be sued on the civil side, but that's quite different than being prosecuted for a criminal offense. So keep your mouth shut on that. Defensive display of a firearm. This is a statute that we have here in Arizona. We didn't used to have this statute. It hasn't been around that long. It's a pretty good statute in my opinion. It deals with the situation where you've got a firearm on your side and somebody is presenting a threat of what I'd call ordinary physical force, right? Well, in those cases, you don't get to use deadly physical force or even threaten deadly physical force. Why? Well, because I just told you a little while ago that the force that you use in self-defense needs to be proportionate to the threat. And if you pull out a gun against somebody who's only threatening ordinary physical force, I'm going to slap you in the face, well, then those people were routinely getting prosecuted. So defensive display is a way to allow people to sort of present their firearm in a defensive manner, a protective manner. What does that mean? In Arizona, this is a specific to Arizona statute, it means really you're either telling somebody about a firearm, you say, hey man, you're not going to slap me in the face, I want to let you know I got a firearm. Yeah, you're allowed to do that under Arizona law if the threat is a real threat against you. It's even of ordinary physical force. You can tell them, hey, I got a firearm. You can also put your hand on a contained firearm. You can take your firearm out and display it in a protective manner. Now, I know what you're thinking. Hey, Mark, what's a protective manner? Answer, I don't know. Nobody knows. We don't have any cases on this right now. I can tell you, I'd sure love to argue that this is a protective manner. I think I could make that argument. If you want to be the guinea pig on that case, we can make that argument. But that's probably not smart. So if you find yourself in this position, assuming that you have already followed my advice about get out of there, retreat if you can safely, diffuse the situation in some way, say all of those aren't options, and you've got to pull out your firearm to sort of repel somebody's threat of ordinary physical force, then what I suggest you do is be very careful with the firearm. You don't want to point it at the person. I recommend you back away while you're saying this and say, look man, I don't want any trouble. I'm pointing this up or down, and I'm backing away from you. Leave me alone. Don't bother me. That kind of looks more to me like a protective manner. If you're approaching and you got the gun pointed in somebody's face, probably a prosecutor is likely to say, so I'm not going to let that sort of come under defensive display of a firearm. Now, of course, this is a jury question. But remember, when you're dealing with a jury in a criminal case, you don't know who you're dealing with, right? You're dealing with a randomly selected group of citizens from the local community who you don't know and you know very little about. As it turns out, when we pick juries, we ask them questions, this is true. But if they turn out they're very pro-self-defense or pro-gun, most of the time a prosecutor in a self-defense case is going to get rid of them. If they're very anti-gun or anti-self-defense, they answer questions and they say things like, well, I don't know why anybody has a firearm. I don't think people should be allowed to have firearms. That's probably not somebody you want on your jury in a self-defense case. So yes, we'll get rid of that person. But you're left with these sort of people in the middle you don't know anything about. And what I'm suggesting to you is you probably don't want to let the next 10 or 20 years of your life ride on what some randomly selected person from the community thinks is reasonable. So again, I'm back to my most important piece of advice here. Be very conservative when you carry or you possess a firearm, or even more broadly, when you use self-defense. Even if you're going to make a fist and punch somebody in the face. If you can avoid that, even if you would be justified, it's best to avoid it, right? Because normally what we fight about in court is not the law. We lawyers, we know what the law is. What we're fighting about are the facts, right? Which means it's not about just what happened. It's about what the witnesses say happened. And that can be very different than what actually happened. So the best play here is to just avoid the whole situation if you can. And I recognize not all situations can be avoided, and so you need to be prepared to act. If you're going to carry a firearm, I should mention this as well, know how to use the damn thing, right? Get down to the range, get some proper instruction, know which end the round exits from, know how to operate the safety if you got a safety, make sure you're hitting what you're aiming at, be proficient with the firearm. I mean, that's part of your responsibility as a gun owner. If you're going to be a gun owner, don't make us all look bad, right? Be a responsible gun owner. Know what the heck you're doing with your firearm. Have some understanding of the law, keeping in mind that at the 30,000-foot view, it's about reasonableness. And that's what I'm sort of giving you some of this reasonableness stuff. Couple little knickknacks here at the end. We've got a law now in Arizona where if you are detained by a police officer and the police officer asks you, hey, do you have a firearm in your vehicle or on your person or something? The law requires you to answer that question. Now, I have questions about whether this is a constitutional rule, right? Because you have a right to remain silent. And if indeed answering that question subjects you to criminal liability, say you're a prohibited possessor, and in violation of the law, you've got a firearm. Well, you shouldn't do that in the first place. But if you answer that question to the officer who says, do you have a gun? And you say, yes, officer, I've got a gun, you're in essence incriminating yourself. So I think that there's some questions about whether this rule is constitutional, but that's the rule. And if you don't answer the question, or you lie to the police officer, then you're committing a misdemeanor crime here in Arizona. This is the type of thing that you might want to check what your state's rule is if you're watching this video outside of Arizona. Find out what the rule is here. In addition to that rule, in Arizona, the police officer also has the right to now seize the weapon during the stop. They generally will give it back to you at the end of the stop. I have questions about whether this is constitutional as well. This to me seems like a taking, however brief, still a taking without due process. So this also seems unconstitutional. But you should know, if you're in Arizona and the police officer learns that you've got a firearm and you're detained, and the officer says, I'm going to take your gun during the traffic stop here or during the detention, the officer has a right to do that. So certainly I don't recommend that you get into an argument with the police officer, or even worse, get into a physical dispute. By the way, while we're on that point, I should also mention that you do not have a right to resist an arrest. Now, this is true even if the arrest is unlawful. Let's say the officer says, hey, you're, so-and-so, and you say, no, I'm really not that person. And the officer says, yes, you are, and there's an arrest warrant out for you. Well, you know beyond a shadow of a doubt that the officer is wrong. But the officer says, put your hands behind your back. You still got to do that. And if you don't, you're going to be hit with resisting arrest or some other type of a crime, because in most states, and certainly in Arizona, you do not have a right to resist even in unlawful arrest. Now, in Arizona, there's a little bit of wiggle room here, because the statute actually says unless the officer is using more force than is allowed by law. So I think what the legislature might be thinking there is you're in an excessive force situation where the officers may be beating you or something. Okay, fine. Very, very hard to prove in court. So the general rule is if the officer says you are under arrest, whether the officer is right or whether the officer is wrong, that's the end. Put your hands behind your back, that you're done. You're not in an argument with the officer. If they're wrong, you get a good lawyer and we'll sort it out later on in court. There might be a civil suit, there might be damages, but this is not a good time to get into an argument with the police. Never is it a good time on the side of the road, especially to get into an argument with the police about what your rights are, what the Constitution says. If they say you're under arrest, if they say get out of the vehicle, you got to follow those orders or you're going to get yourself in trouble. So anyways, I think I've covered the main points about self-defense. Just to finish up here, again, my name is Marc Victor. I'm with the Attorneys for Freedom law firm. You can find us really easy on the internet. Just go to attorneysforfreedom.com. You'll find lots of information. There are many, many more videos on our website on self-defense and other aspects of criminal law. I also want to mention too that we are one of the few firms that actually also does civil rights litigation. So if you've been the victim of, say, police brutality or some other government actor has violated your rights, that's the kind of thing you might want to call us. We bring those cases. I will tell you this, we don't bring them recklessly. We look at them very carefully. If you've been wronged and you've got a good case and there's damages that warrant a lawsuit, we're not afraid to bring that suit, whether it's against the local government, the federal government, or any government agency. I got to confess, we kind of like suing the government in a legitimate case, okay? So if we turn you down, it might be because we think the law allows the officer or other state actor to do that type of act. Whether we like it or not is a different question. Or sometimes they violated your rights, but there's just not enough damages. You can call us if you've got a question about that. We also do personal injury and wrongful death cases. We do those nationally. So if you have a personal injury or wrongful death case, we can take that. We do all cases nationally. I've done many cases in many other states. There are some rules that allow us to appear even in your state. There's a rule called pro hoc vice, which we use fairly frequently to go to other states. And then finally, I want to mention the Attorneys on Retainer program. This is a very important aspect of what we do here at the firm. It's a way for you to get us on retainer at dramatically reduced rates. You can get me and my team on your case for $175 an hour, no matter what type of a case it is. Even on a murder case, $175 an hour. The catch is you got to act before you need us. You have to sign up in the Attorneys on Retainer program in advance. And the way it works, it's roughly $20 a month. There are some discounts for groups and things like that. Check us out online. Just go to Attorneys for Freedom and click on the Attorneys on Retainer, sometimes shortened as AOR, on our website, and that will detail all this information. It's a really good program. We got lots of members. It's growing all the time, and there are lots of other bells and whistles that you get by being a member of the Attorneys on Retainer program. But most importantly, you'll have us standing there in case you ever need us, which I hope you don't. I hope you take my advice in this video and you never need us. But in the event that you do, you will know in advance that you have us available and you can actually afford us at $175 an hour rather than something north of $500 an hour. So I hope you'll consider the Attorneys on Retainer program. You can always get a hold of me through my website, attorneysforfreedom.com. My name is Marc Victor, that's M-A-R-C-V-I-C-T-O-R, and I hope you found this video informative. And if you have questions or concerns or comments, I'd love to hear from you. And you can email me directly at Marc, M-A-R-C, @ attorneysforfreedom.com. Thanks for your time.